The Women's Safety and Justice Taskforce, an independent and consultative task force, has just delivered our second report, Hear Her Voice 2, to the Queensland Government. Hear Her Voice 2 follows on from the task force's initial report on coercive control and domestic and family violence, Hear Her Voice 1. The Queensland Government has supported, or supported in principle, all recommendations in that report. In this second part of our work, the task force, as required by our terms of reference, has examined the experience of women across the criminal justice system, including the barriers faced by girls, First Nations, culturally and linguistically diverse, incarcerated and elderly women, those with disability, or living in rural, remote and regional areas, and the LGBTQIA+. The task force focused on two strands of the experience of women and girls in the criminal justice system, first as victims of sexual assault, and second as accused persons and offenders. These two strands initially seemed distinct and unconnected, but the task force came to realise there was unexpected overlap. That was because the criminal justice and corrections systems were principally designed, and until comparatively recently, administered by and through the lens of men. They do not focus on the needs of women, whether as victims or offenders. I found this realisation confronting, given that I'd been a barrister and a judge in the criminal law for over 40 years. The task force received 252 submissions from victim survivors of sexual assault and 19 from offenders. Over half of those 271 submissions were from women and girls who were also victims of domestic and family violence. This demonstrates the significant link between the task force's work for this report and our work for Hear Her Voice 1. On this part of our work alone, the task force held 79 consultations and engagements with stakeholders including the judiciary, legislators, police, policymakers and public servants, academics and lawyers. Over its 16-month life, the task force held over 202 such meetings. No wonder we're all feeling tired. The task force has listened to and acted on the voices of victim survivors of sexual assault. They told us that rape myths, commonly held community misconceptions about sexual assault, made them feel blamed and shamed, and that this added to their trauma. They wanted the stigma about acknowledging and confronting sexual assault, prevalent throughout Queensland and particularly poisonous in some small regional, isolated and First Nations communities, removed. Knowing that they will be supported, not shunned, is the first step towards victim survivors feeling safe enough to report sexual assault. Victim survivors told us they want changes to the law about sexual assault, so that the focus during the investigation and trial is not on what they said, did, drank or wore, but on the actions of the accused person on trial. And they want the community to be better educated about sexual assault, its impact, the flaws in rape myths, the law relating to sexual assault, and the fundamental importance of healthy, intimate relationships based on respect and mutual agreement as to consent. Victim survivors told us that they want police to treat them with respect and in a non-judgmental way, even if they're not the traditional perfect victim. To have forensic samples collected quickly and in a trauma-informed way, and then stored and analysed to ensure reliable DNA evidence can be given at trial. To be supported through their ordeal as soon as they seek help. To make their own informed choices and to be updated about the progress of the case so that they can manage their life as they seek to rebuild it. The task force makes 92 recommendations about the experience of women and girls as victim survivors of sexual assault. In making these recommendations, we've taken care not to compromise the accused person's right to a fair trial, a fundamental principle of our criminal justice system. The task force intends that these recommendations apply to all Queenslanders wherever they live in this huge decentralised state. That is why it has recommended increasing digital inclusion with improved internet coverage for equitable access to services across Queensland. All recommendations have the unanimous agreement of the 11 Taskforce members, save for 2 areas of law reform, which are majority recommendations. By an 8-3 majority, the Taskforce recommends amending the law to provide that no regard must be had to the voluntary intoxication of an accused person when considering whether they had a mistaken belief as to consent to a sexual activity. And by a 9-2 majority, we recommend the law provide that an accused person's belief about consent to sexual activity is not reasonable if they did not, within a reasonable time before or at the time of the activity, say or do anything to find out whether the other person consented to the sexual activity. We recommend, however, an exception for accused persons whose communication skills may be relevantly affected by cognitive or mental impairment. We also recommend that these changes be delayed for at least 6 months after becoming law to facilitate a community education campaign and the establishment of a panel of experts to give evidence about those claiming cognitive and mental impairment. We recommend other significant law reforms, including amending the definition of consent so that it must be freely and voluntarily agreed. If the victim survivor has suffered grievous bodily harm during the alleged assault, those injuries will be proof of lack of consent unless the accused person establishes otherwise. Stealthing. When 2 people agree to sexual activity on the limited basis that one will wear a condom, but that person later intentionally removes the condom and continues with the sexual activity, is rape. A review of the legal capacity of children and young people, aged 12 to 15 years, to consent to sexual activity, and of terminology used in the criminal code, such as carnal knowledge. Widening the admissibility of evidence in sexual assault cases. In a link to the Taskforce's work on Hear Her Voice 1, we recommend an innovative reform extending the use of preliminary complaint evidence, usually only admissible in sexual assault trials, to domestic and family violence-related cases. The Taskforce recommends a community education campaign about sexual violence, including the need for adults to reach clear and mutual agreement about consent, breaking down taboos around talking about sexual assault, addressing the harmful messages and rape myths, including in First Nations and other diverse or remote communities, ensuring relationships education is delivered to a common high standard in every Queensland school, with children and young people understanding that healthy sexual relationships are not what they might have seen in the violent, damaging pornography which endangers and diminishes women and girls. Professional development to better understand sexual assault and its impacts on victim survivors for police, law students, lawyers, judicial officers and service providers like medical professionals who treat sexual assault victims or take forensic samples. The Taskforce recommends improving the experience of victim survivors of sexual assault from the time they seek help until the accused person is tried or sentenced and beyond, through processes to ensure they are treated with dignity, respect and their voices heard in their dealings with police, prosecutors, victim liaison officers and defence counsel. New processes for the way victim survivors give their evidence in court. Minimising court delays through improved case management of sexual assault trials. Victim advocates to assist victim survivors navigate the criminal justice system. An independent victims commissioner to promote and protect the needs of victims of all violent offences. Media organisations made submissions urging changes to closed court and non-publication rules relating to court proceedings for applications for domestic and family violence protection orders and in serious assault cases. Victim survivors and their advocates, however, told us that open hearings would be re-traumatising. They did not want change. The Taskforce listened to their voices and is not recommending these changes, but we do make other recommendations in the interests of judicial transparency and accountability, including media access to de-identified transcripts of these proceedings, removing the present prohibition on the naming of accused persons in serious sexual assault cases prior to committal, allowing victim survivor children or young people aged 12 or over, with certain protections for them and others, to speak publicly about offences committed against them. The Taskforce recommends improving forensic examination processes for victim survivors of sexual assault and ensuring the evidence obtained is optimally stored and then presented to and understood by lawyers and courts. Some victim survivors told us they would have preferred restorative justice to the criminal justice system. While accepting there can be dangers in restorative justice for some victim survivors, the Taskforce recommends strengthening, developing and further considering the presently very limited restorative justice programs available in Queensland for sexual offences. The Taskforce hopes that these 92 reforms will improve the experience of victim survivors of sexual assault without compromising the accused person's right to a fair trial. The criminal justice system is also used by women and girl accused persons and offenders. Although they commit far fewer offences, especially violent offences, than men, the number of female offenders has grown by almost 4 times the male offender growth rate. Proportionally, Queensland has more women in prison than other states. Numbers of First Nations women in Queensland prisons have grown by 120%, and numbers of non-Indigenous women by over 80%. At a cost to the community of around $120,000 a year for each prisoner, jail is expensive. Even worse, it's not working, it's not keeping the community safe by reducing recidivism. Queensland women in prison are rapidly increasing in numbers, but they remain invisible, vulnerable and largely ignored by the outside world. Yet they too have human rights under Queensland's Human Rights Act and international law. The Taskforce visited women's prisons and a youth detention centre and listened to the voices of offenders. We spoke to women who had recently left prison. We heard from those who work with these women and girls. All offenders were victims of domestic, family, sexual or physical violence. Many were victims of multiple forms of violence. We learned that prisoners who have far greater physical and mental health and disability support needs than the general population lose their Medicare and most aspects of their NDIS entitlements at an opportune time in their lives to address these needs and their impact on the prisoners offending. We heard how few rehabilitative, healing and education programs are available. We saw the draconian conditions of the safety and detention units. We heard heart-wrenching stories of women who had miscarried or had stillbirths in prison without access to appropriate medical care. We learned of their low pay rates for prison work and the high charges for those treasured family phone calls and for personal items on their limited buy-up list. We heard of the difficulties for criminalised women returning to the community to rebuild their lives and their broken families. There are fewer women's prisons than men's prisons. As Queensland is such a physically large state, this means women are often imprisoned far from family, making contact difficult and their time in custody especially onerous. We learnt that the housing crisis is so acute that women eligible for parole are not released as they cannot find a single room anywhere in Queensland to live. Our 84 recommendations dealing with women and girls as accused persons and offenders are aimed at ensuring their voices are heard when sentenced, keeping them out of jail where possible, and helping those who are in jail rehabilitate so that they can return to the community and not reoffend. Jails impose a huge cost on the community. There are more women in prison than ever before. Prison is clearly not working to stop recidivism and keep the community safe. New strategies are needed. The Taskforce recommends a public health and justice reinvestment approach to women and girl accused persons and offenders, from first contact with police, through the justice system, into the corrections system and beyond, with a specific focus on the needs of and impacts on First Nations women. We recommend training for police, law students, lawyers and judicial officers on gendered issues such as best practice in interviewing First Nations women and girls and other vulnerable cohorts, and understanding the impact of trauma and abuse on offending behaviour. Reviewing our present response to bail for women and girls. Limiting the time women and girls are held in watch houses. Separating women remand prisoners from those serving sentences. Strengthening and expanding diversionary schemes. Broadening the matters relevant to sentencing to include female-focused concerns, such as the effects of trauma and the needs of dependents. Providing for more community-based corrections orders. Increasing the use of pre-sentence reports and rehabilitative programs focused on the needs of women and girls. Decriminalising sex work. A review by a non-partisan parliamentary committee as to whether minor drug matters and offences such as drunkenness should be dealt with under the health rather than the criminal justice system, as in many other states. For women and girls in custody, the Taskforce recommends addressing their health and wellbeing needs, including pre- and postnatal care and birthing. The deaths of children born to or living with women in custody and stillbirths to be reportable deaths in custody for the purposes of the Coroner's Act. Strengthening and making the prison's complaints process more transparent. Non-invasive body screening technology to end strip searches of women prisoners, many of whom are victim survivors of sexual assault. Reviewing prisoners' working conditions and pay and the availability of educational, health and rehabilitation programs. Assisting women leaving prison to find suitable housing and employment to help break the cycle of offending, prevent recidivism and protect the community. There are also 12 recommendations about data collection and implementation. This report has been another mammoth undertaking in a short time frame. Over the past 16 months, my talented Taskforce members have generously volunteered their time and enormous wisdom and energy while working in demanding full-time roles. My small secretariat has again been extraordinary in their diligence, commitment, energy and vision. I owe each of them an enormous debt of gratitude. So does Queensland, especially its women and girls. Emma Hollingsworth, the First Nation artist who created the splendid Journey to Justice on the front covers of the Hear Her Voice reports, explained the symbolism of her work. A woman travels along journey lines, surmounting all hurdles, until in the circle on the top right-hand corner, represented by the U-shaped symbol, she is home in her circle community, resting in comfort and safety, having completed her journey to justice. It is so apposite to those whose voices have informed this report. I commend Hear Her Voice to the Government of Queensland, to all Queensland legislators, policymakers, the media, community members, service providers, corrective services officers, police, prosecutors, lawyers and judicial officers. Together we can ensure that our justice and corrections systems reflect the need of all Queensland's women and girls, victims and offenders alike, wherever they live in this vast state, especially our First Nations women and girls, if we hear her voice.